Hello and welcome, welcome, welcome. We are live streaming the closing arguments for the Kelsey Fitzsimmons trial. They are already in the courtroom. We are going to go ahead and begin. I hope that you are doing well. It is Thursday, the 26th of March. So hope everybody's doing well and that your weather is great. We're going to go ahead and begin because we don't want to miss a thing. All right, here we go.
That day was about her, and she decided in the midst of...
Okay, we're going to back up.
All persons having anything to do before the Honorable Jeff Carter, Justice of the Superior Court, now sitting in Lawrence within and for the County of Essex. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This is the Honorable Court. Court is now open. Please be seated.
Good morning, Your Honor.
Good morning.
God save the Commonwealth.
2026, Court in 2, Lawrence Superior Court. Calling the criminal matter of Commonwealth versus Kelsey Fitzsimmons, 2025, 77 CR 311. Scheduled today for continued jury waive trial. Could counsel will please identify themselves.
Good morning, Your Honor. James for the testimony.
Good morning. Good morning. Good morning.
Good morning, Your Honor. Martha, please, for the defendant.
Oh boy.
Good morning, Ms. Fitzsimmons.
Good morning, Your Honor. Timothy Bradle, Ms. Healy, Ms. Hassan, Mr. Leonard.
Good morning, everyone. Thanks. You can have a seat. All right, so you folks ready to proceed?
Yes.
All right.
Oh
I
boy.
say this for the attorneys who know this, but because the government, the prosecution has the burden, they go last. The defense goes first in their closing. And
Interesting.
Mr. Bradle, you may proceed.
Thank you very much.
Wow. I didn't know that. Okay. Well, defense up first. All right, Mr. Bradle, let's go. Come on. Ooh, I like your notebook. Looks like mine. Well, I like mine. I have a little thingy in mine.
May it please
I
the
like
court,
mine.
counsel,
Whew.
ladies and gentlemen. Your Honor, June 30th, 2025 was the worst day in Kelsey Fitzsimmons' life. Her whole world imploded. Her
Use that same
fiance
word.
betrayed her. Her baby was being taken away. She was going to lose her house, her job.
And her dog.
It was an incredible confluence of tragedy that was visited upon her that day. That day was about her, and she decided in the midst of what you saw testified to here, she decided to end her life. Patrick Noonan, when he came back up those stairs, Your Honor, walked into a suicide in progress. That gun was nowhere near him. That gun was already pointed at Miss Fitzsimmons' temple by Miss Fitzsimmons. She was a couple steps into the room.
Wow. Oh my
Officer
gosh.
Noonan, a gung-ho cop, highly trained, a SWAT guy. He'd already been ginned up all afternoon by the insane, ludicrous statements of Justin Elaine. He had that in his head. He walked in, and like all of us are susceptible to, he made a mistake. He shot too quick. He reacted too quickly. And instantly, he realized that he had to adjust the narrative. And that was easy, to just add 6 words to the equation, Your Honor. He said, words to the effect, she pointed the gun at me. 6 words. What did those words do at that time period? Those words made him the victim. Those words made him the hero. And those words, most important, made him untouchable. Those words were a defense for his future, his life, his reputation, and they were they were conveyed to a very willing audience. His colleagues, his brothers, his family, the investigators on the case. So that's really what happened here, Your Honor, and it is a tragedy, and it is something that should not result in any further harm to Ms. Fitzsimmons. This should be over. This should be an acquittal, Your Honor. I want to talk to you about a few of the elements that I know you're going to be concerned about. So first thing I want to talk about, Judge, is the lack of motive and the lack of intent. Because when it gets down to brass tacks, I know that you're going to look at the law, you're going to look at the credibility determinations, and you're going to make your judgment. And here, this case fails the Commonwealth Ship founders on the rocks of lack of motive and lack of intent. Let's talk about motive. Everything in life is motive. And it's ironic that, us lawyers always say, oh, well, you don't need to prove motive. But you really kind of do. It might not be an element of the crime, but motive is everything in this business, Your Honor. Let's look at the motive or lack of motive. Fitzsimmons and Noonan are colleagues. They have already bonded over shared tragedies, shared experiences. They were okay with each other. They were friends. Kelsey thought well of him, and she thought he thought well of her. She knows he has a family. She knows who his family is. She's not going to harm this guy. She knows, Your Honor, that he didn't do this to her. She knows that Justin Elaine did this to her. And she's probably most important, she's been in those shoes before, serving restraining orders. She knows she's just a messenger. She knows he's just a messenger. This was the worst moment of her life, and she wanted to end her life. And how did she want to do it? She wanted to do it alone. She didn't want to involve these officers because she knew this was a selfish act. She came in here, and ironically, the most credible evidence that came into this case, Your Honor, was from the one person that didn't have to testify. And she came in here and she chose to testify. And she waived her rights and she testified. And she showed, Your Honor, that she's a moral person. She's a caring person. You will sit down and you'll deliberate, and you'll be drawing the inevitable conclusion that Kelsey Fitzsimmons is a moral person. You have to contrast that with the callous treatment of this case from the other side. Hey, we're going to go serve an order on Kelsey Fitzsimmons. Her ex-fiance got an order on her, on Kelsey. Let's go serve an order. The answer, sounds good. Let's go.
Right, with no
Talks to his
planning.
neighbor. Oh yeah, I'm the shooter. I'm the shooter. She's a whack job. So you have to take these credibility determinations into account. And I know you're a gentleman, but you have to get down to brass tacks on who's who here, Your Honor. What else shows you that she's a moral person? She doesn't want to involve these guys. She's trying to get rid of them. She says, oh, the guns are over here, so she can go where they really are. She keeps trying to give Houston and Noonan baby things to bring downstairs. She's trying to get rid of them. She's trying to get them away from her. She wants to do this on her own. She doesn't want to have some sort of a situation where she gets shot by one of her colleagues and friends. It's understandable because she's a moral person. She waits for her chance. She gets to her room. There's a distraction downstairs. She doesn't know what's going on because she's focused on the job she's trying to do here, the tragic, awful thing that she's trying to do to herself. That's how you know she's telling the truth, Your Honor. You saw in the room, and I'll show it to you in a minute, the chest that she got the gun from. It's a chest on the floor. It has one of those pretty substantial lids that you would have to flip up to get the gun, locate the gun, pick the gun out of the 4 guns, and stand up. If Noonan was standing right there in the door frame, that would have never happened. All those events, that little series of events, he would have been able to stop it. He would have stopped it. It tells you that he's down the steps. He was interested in the distraction downstairs. He saw Kelsey folding some baby clothes, getting baby things ready. His attention, it's human nature. His attention was drawn to go back down the stairs. He walked down the stairs 2 or 3 steps, 4 steps, whatever. And Kelsey told you straight up, that was my chance. And she took it. And she went in the chest. Exhibit 51, Your Honor. I'll show you right now.
Right. She had to open up that chest. That box
She went in
wasn't
that
there.
chest,
She had to open up the chest.
flipped up that lid, got the gun, stood up. She told you, again, she's a moral person. She tried to
The chair
keep
wasn't
the gun
there either.
concealed. She made the motion like this, Your Honor, where she put the gun like this, and she kind of walked over here because she didn't want the police to see her with a gun. She held the gun to her stomach area. She walked to a clear area, and she put the gun to her head. And that's what I mean when I say Officer Noonan came back up the stairs, and what did he walk into? He didn't walk into some Rambo woman trying to shoot him in the face.
This is
He walked
Officer
into
Noonan.
Kelsey, who you now know a little bit from her testimony. He walked
Officer
into
Noonan
Kelsey's
shot
room,
her in the chest.
and Kelsey had a gun to her head. And he walked into a suicide in progress, Your Honor.
Noonan was her colleague. They worked on the police force together.
And the man that had just been holding her baby,
Wow,
that
look at
she
him.
chose to hold her baby,
He's red right
She
now.
chose
He's
to feed her
super
baby.
red.
walked into her suicide in progress. The gun was nowhere near Noonan. There was no threat to Noonan. And the law says
Right.
that you may not, an officer may not use deadly force
Deadly
on
force.
someone who is exhibiting a danger only to themselves.
Themselves.
And
Yep.
that's offered to Your Honor twofold, in the sense that it shows that this was not a reasonable use of force, and it shows you that his knowledge of that statute, as he said on the stand, gives him a motive to lie. He knows that this is not a good shooting. He knows this is not a clean shooting. And that gives him a motive here, Your Honor.
Wow.
And like all of us, we all make mistakes. He overreacted and he shot. He had the look on his face, panic, flustered, he shot.
That's not
He
proven.
made a mistake by leaving her there, walked down the steps, a few steps, and that gave her the chance. And when he did this, he knew immediately, Your Honor, that he had to adjust the narrative.
Well, they also made the mistake of not clearing the house of the weapons.
Filtered
they were
through
there
the
to secure.
legal lens, Your Honor, that tells us that Kelsey had no intent. She had no intent to harm.
Right, she had
There's
no intent to
assault
harm.
here because she didn't have the intent to do so. As the fact finder, you can consider everything I said about motive, that she lacked any motive to harm this gentleman. In fact, it was the opposite. She thought well of him. She knew Justin did this to her. She had just trusted him with her baby, and she had tried several times to get these officers away from the situation. No intent to harm him,
Right.
no motive
Right.
driving her mindset to do so. Reasonable doubt, burden of proof, Your Honor. Where the evidence supports a reasonable and more plausible alternative, and that's shown here by Kelsey's testimony, it cannot be said that Commonwealth has proven their case beyond a reasonable doubt. There is reasonable doubt when there are two plausible versions of what happened. That itself is reasonable doubt. The versions themselves, Your Honor, show reasonable doubt. Kelsey's version rings true. Noonan's version is all over the place. Noonan's version is contradicted by the the strong consensus of everybody else in the house. Noonan portrays a couple different stories,
Right.
but if you want to pick one where it's this drawn out potential gun battle, where she's backpedaling, sidestepping, tapping, racking, there's commands going on, that takes time. It takes time
Right.
for me even to say it.
Right.
Never mind do it.
Right.
And that's belied by everything everybody else in the house says. Everyone else says, Kelsey, no, 2 shots
Bang,
in
bang.
quick succession, bam, bam.
Right.
That does not fit with what Noonan said happened. So
Right.
on that alone, Your Honor, as a
Because how
fact
can she
finder,
get the gun,
I suggest
have
that
the
your
jump on
duty
him,
is
tap, rack, step,
accomplished
step.
quickly, because
She
there are two
supposedly got
extremely
the gun here and
versions of
stepped
this
back here,
event.
and she was shot back up here.
And Noonan's version has changed itself.
Yes.
Noonan's version is inconsistent with who you now know Kelsey is as a person. It's self-serving.
Stop with the characterization. He can't go off of characterization. He has to go whether she did or did not do
And
the
like
things.
I said, it makes him untouchable.
Come on, Bradle.
And when you judge it against everyone in the house, he's the only one with the Rambo story. Everyone else has what Kelsey says. He walks into a suicide in progress. He sees it. He reacts. Kelsey, no. Kelsey, no. Bam, bam. Brain freeze. Mistake. Has to cover it up immediately. What else do we have? You know, when you're a fact finder, Your Honor, you want to look for corroboration. What's the corroboration on either side of this thing? Or lack of corroboration, which is what really it is here. The big one, the big elephant in the room is that this department has no body cameras. We wouldn't even be here if they had body cameras. There's no evidence other than people's words. He said versus she said. That's
It's a he said, she
oftentimes,
said.
almost all the time, not a good place to start for the Commonwealth.
Yeah.
How many of these guys didn't do reports? What's up with that?
Yep.
Why
no
didn't
reports.
Trooper Strong put the body camera video on the witness he's interviewing? There's no science.
No science.
The
No
testimony
recreation of
everyone
the scene.
else in the house shatters his narrative. Kelsey Fitzsimmons has been blessed. She should be dead 2 times over, by her own hand and by the hand of Officer Noonan, who shot too quick. She's blessed. She's here today, and she has a new lease on life. And maybe that's why the investigation is what it is. And maybe that's why Noonan's story is so sloppy, because nobody expected her to be here today to tell her truth. But
Yeah.
she is, Your Honor. And as the fact finder, I want to respectfully ask you to consider the evidence, consider the lack of motive, the lack of intent, the inconsistencies. The credibility contest is firmly in her camp. She came in here and she told you what happened. Unvarnished truth. And I ask you to find her not guilty. Thank you, Your Honor. Thank you.
Interesting. I wish you would have gone into a little bit more of oh, there's strong. Oh, interesting. Oh, crap. I wish that they would have gone into lack of whatever the police did not do. Okay. Strong's getting the gun out.
I may,
Yes.
Oi!
I may.
Yes.
Every piece of credible evidence in this case proves one thing, that she's guilty. All the testimony, scientific evidence, the physical evidence, the demonstrative evidence, everything points to one conclusion: she is guilty. Even her own testimony proves she's guilty, because it's impossible to have happened the way she said it. It is scientifically, mechanically impossible for it to happen the way she said it.
How?
Her story is that she grabbed a gun, put it to her head, pulled the trigger, and it clicked. The chamber was empty. That's what her story is. And that's what Officer Noonan's story is, too. She pulled the trigger, click, nothing came out. There wasn't a round in the chamber. She even said, she told everybody how stupid I am. I tried to kill myself with an empty gun. But what do we know about the gun? What do we know about her gun? Because after she went to the floor, Lieutenant David picked it up, put it on the bed. Officer Noonan picked it up and put it on the table. And then Officer Kaur came in the room. And what happened then? Officer Noonan said, secure that gun, make it safe. And so what did he do? He took the gun, he found that black box, the safe, and made sure that was empty. He turned it over. He pulled out the magazine that you can see right here. He opened the chamber, and there was a round in the chamber. He dumped it out into this safe and put the firearm in there. And then they stood watch on that until State Trooper Bonasara took it back.
I thought this was going to be a bone of contention. I wish that Grado would have addressed this.
Contains 16 rounds. It was a 17-round capacity gun. It contained 16 rounds, plus the one that was in the chamber. 17 rounds. As we know, there are only two ways to get a bullet into the chamber. One is if there's already a bullet in the chamber. Someone pulls the trigger. A bullet comes out, the casing comes out, the chamber's open, the spring allows another bullet to come up. That's one way, and we know that didn't happen here. The gun didn't fire because the chamber was empty. The only way a bullet gets in this chamber, other than that way, is if someone racks the gun. She said she didn't rack the gun, but there was a bullet in the chamber. She did rack the gun. What did Officer Noonan say? She pulled the trigger. Nothing happened. She stepped back, tap racked, tried again, didn't do it. Tap racked again, pulled it, and that's when he fired. She put a round in that chamber. That's the only way it got there. Her story can't be true. She got up on that stand and she lied to you. It's scientifically and physically impossible for her story to have happened the way she said. That's what the evidence shows. But she didn't just lie to you then. She lied again. She lied at the scene about where the guns were. And she admitted that, and I understand that, right? And she said she lied to the police because she decided to kill herself. But when did she say she said that? They had been to the house. They had talked to her, according to her. She now started contemplating all of the ramifications of what's going to happen to her because she's losing her life, her job, her son is being taken away, all of these things. And so
And
she's
her
going right
dog.
over her head. And then minutes later, as she's walking through the house, she says, my gun's in the basement, because that's the time she made the decision to kill herself. Later on. And we know that's a lie. We know that's a
True.
lie because what was one of the first things they asked her when they went to that house? They asked her to put the baby down because they were concerned for the baby, told her the restraining order, what the parameters were, and asked her where your guns are. When she was still sitting on the sofa. They weren't waiting to ask that question so she was already walking around the house. No way. And what did she say there? They're in the basement. And we know she said it there before she moved around the house, which is untrue. Because her friend, Officer Houston, who was invited to her wedding, says it also. He says, Sergeant Daly asked. And then remember what he said? He said, I was in the living room, she was sitting down, and then I saw a gun case on the other sofa. And so I opened it up to see. And she said again, I already told you the guns are in the basement. Now, why at that point did she say that? We don't know. She didn't tell us, because she lied to us about why she said it later, because we know she didn't say it later. So she lied again. You can't trust her. She also lied about knowing that her mom was in the house. She was upstairs. The officers, Noonan, I think it was, Noonan heard an older woman's voice down there and said, who is that? She says, I have no idea. She doesn't know her own mother's voice, her best friend that she just talked to come to the house. And she said she didn't know whose voice it was. Another lie. She said on the stand yesterday that she didn't know Justin was in the house. And we know that's a lie too, because what happened when the three of them were upstairs? It's Noonan, it's Houston, and it's the defendant. She hears him downstairs. Houston hears him downstairs, and she says, keep him away from me. I don't want him in my house, or something to that effect. And that's when Houston went down to make sure he wasn't coming up and went to the basement. She knew he was in the house. She absolutely did, and she lied to you when she said she didn't yesterday. And you know what else she lied about? Something so simple, but it shows who she is. The restraining order. She said, the restraining order was taking my dog away. It says it. It doesn't say that. Nothing about the dog in there.
Oh.
I could go on about the lies, but I want to talk about the credible evidence. The credible evidence in this case. When Lieutenant Daly got a call, actually got a visit from Justin O'Lane when he was in the lobby of the PD. And Justin told him he got a 209A against Kelsey Fitzsimmons. And Detective Daly knew that she had been sectioned before, that she had guns, that they were taking the child away from her for a period of time. And so what did he do? He called Officer Houston. He asked Houston to call Daly to meet up. And why did he say he did that? He said because those two are cool, calm, and collected. They don't panic. They keep things calm. That's what he said. And that's why when he called Houston, he said, can you call Daly? We got to do this. And so he wants you to believe, defense counsel, that Pat Noonan was cavalier about, oh, okay, sounds good, we have to serve a restraining order. But that's not what happened. He was mischaracterizing it, I hope you remember, in the grand jury minutes, because Houston had called Pat and said, hey, we got to serve an order, can you meet me by the school? And Pat said, sounds good. It wasn't until he got over there, it wasn't until Lieutenant Daly was there that they learned really what they were going to do. And they went over there. And defense counsel asked Daly, you guys were cavalier about it, you knew her, weren't worried about the guns, all this stuff. And Lieutenant Daley said no. No. His quote was, "We had an increased level of diligence. Everyone was more on point because they did know what they were walking into. They did know. They did know that she had been sectioned before. They did know there was going to be a baby in the house. They did know that she had guns. They did know at that point that she had parked her car far away." This is all going to what they were thinking at that point. They did know all those things. And they did know Justin's concerns. He said, according to Lieutenant Daley, "I'm worried she's going to kill the baby, kill herself, and kill someone else." So that's what they were thinking when they went into this house. That's the credible evidence when they went in there. And what did they do when they went in there? They sat her down, and they allowed her, or maybe they asked her, I can't remember, to go around and get some stuff for the baby because she knew Justin was coming to get the baby. And they were in her pocket the whole time. They followed her around the house, at least two of them, while she did that. And you know that because even Officer Houston said, "I was in her pocket." We went into the kitchen, and I noticed there were butcher blocks with knives on it. With knives in it. And they were concerned. There was no chance they were leaving her alone. No chance they were leaving her alone. Officer Newman. Officer Newman. All of the testimony that you've heard about Officer Newman, even from the defendant, he's a gentleman, he's experienced, he is by the book in his training and experience, starting in the military, through boot camp, through security forces school, security forces squadron, with all the training he had, and Humvees and helicopters, and the SWAT team, 2 times a month training, clearing rooms, clearing buildings, hostage situations, missing persons, shoot, no shoot scenarios, twice a month, and a 40-hour block every year. For over a decade he did that. And he moved to Lawrence, as far as the department goes, because it was busier, and he had more experience. He was cool, calm, and collected. There's no doubt about that. And to say when they're upstairs and he walks away and leaves her alone because he heard a commotion that Officer Houston was going to attend to is a joke. It really is. Now, how do you know they were going by the book at that point? And how do you know they were vigilant? Because they followed around everywhere. Because both Houston and Officer Noonan said she kept handing us things, and we kept putting them down. We wanted our hands free. Because they were ready for whatever happened. Hoping nothing did, but ready for whatever happened. So at some point, Houston and Noonan are upstairs, and the defendant goes into her room. And she hears Justin. And Houston goes down to keep the peace to make sure he's there. And Officer Noonan is watching her. He's watching her. And she's on one knee. And she lunges, and she disappears. And she emerges with this, pointing at him like she is trained to do. Click at his face. And what does he see next? He draws his weapon, and he says, his testimony, it kind of slowed down. The whole thing took maybe 4 seconds, maybe even 3.5 seconds. His training has kicked in. His experience has kicked in. It was a surprise to him, certainly, because she got the drop on. And why did she do this? Who knows? Maybe he's right. Maybe he she was going through him to get to justice. Maybe she was just so upset she was going to shoot anybody in front of her. Maybe she wanted him to shoot her. We don't know because she lied about it. We don't know. But the fact is, she started to shake, she started to tremble, and she lunged for the gun that he couldn't see. And what happened after she flipped? She stepped back, and now he knows, based on his training experience and the clip, there is not a round in the chamber. He knows that, and so he doesn't shoot. According to the defendant's testimony, he had every right to shoot at that point. And you know what? He actually did. He had a right to shoot her at that point. If you point a gun at a cop and pull the trigger, they get to shoot. But he didn't, because he was controlled and disciplined. That's the way his career went. And so she steps back, tap, crack, and tries to do it. He doesn't shoot her then. And what's he doing at this point? Kelsey, no. Kelsey, no. Because he knows the threat isn't there, really, because there still wasn't one in the chamber. Kelsey, no. Kelsey, no. He is being disciplined like we wish every police officer, every law enforcement agent in this country was. He should be applauded for his actions on that day. Tap rack again. Now he knows one's in the chamber. Threat's on. She starts to raise it, and he shoots. He shoots twice to stop the threat. He stopped shooting when the threat was neutralized. Defense counsel, during his cross-examination, well, you would have unloaded her gun. He goes, no, that's not what you do. You shoot until the threat is neutralized. She was now down on the ground. But his training and experience are still taking over at this point, because what does he do? He still has his gun on her, because the gun's still there. He can't see it. Lieutenant Daly comes in, Lieutenant Houston comes up, and what does Officer Houston say that he sees when he comes upstairs? That Officer Noonan is standing there with the gun low and ready. His training is still taking place. He's still doing what he was trained to do. The gun is put on the bed. He's calm and collected. He takes the gun and moves it away so people are safe. He's deliberate in those actions. When it's away from her, he starts to tend to her. Officer Core comes in, and he asks Officer Core to make the gun safe. He's cool, calm, and collected. That's what Lieutenant Daly expected, and that's what he was. He didn't make a mistake. That's what the credible evidence shows. And what did he say to Officer Houston after? And this just goes to state of mind, I know. That she pointed the gun at me, and it clicked. And she tried to rack him up. Immediately after, this wasn't him saving his hide or protecting himself. Seconds after this happened, that's what he said. Every piece of credible evidence points to the unmistakable fact that she is guilty. Every piece of physical evidence, scientific evidence, mechanical evidence, every piece of testimony from Daly to Houston to Core, even Lauren Page, the mother, even the defendant corroborates what Officer Newman says. Every piece. Your Honor, I would suggest to you there is only one fair and just verdict in this case, and that is guilty. Thank you.
Maybe for a sidebar.
I'd like to speak to Councilman.
Oh, boy.
For scheduling purposes.
Oh, sidebar. Oh, goodness. Oh, man. Wow. I don't know. The prosecution was pretty good. Oh dear. I don't know. That round, though, I wish that they would have discussed that round in defense. All right, let's see if they do anything else. They're still at sidebar. Oh man, so I thought that Bradel had talked a little bit about the gun being put into the safe and that round being in there. And they talked a little bit about it, but he did not like circle back to that, which it could have been that I mean, how did that round get there? It's not necessarily that well, the picture is hard to tell. So it's hard to tell if like the gun is if the gun is open and the chamber is you can see the chamber, or whether it's put back together and that round in the magazine are there. It's kind of hard. I'll see if I can look at the picture, but it's hard to see how exactly that is. So I mean, like, who's to say that someone just didn't put a round in there, right? Who's to say that maybe, you know, Noonan picked it up, racked it, and put it down on the bed? I wished Bradel would have said that in his closing and just sort of like answer that question or give hypotheticals to that, because that definitely is was a question for me. So it's hard. This one's going to be really, really hard. And the judge is the finder of the facts in this case. And he is the one that's going to have to make this hard decision. It is a he said, she said situation. How is this going to play out? Well, he has to look at the elements that I discussed yesterday. I can bring those back up. We're waiting to see if they're going to come back.
All right, so while you folks are returning, the council are returning to council table, I'm just going to, we went to sidebar for two reasons. One was Mr. Bradel has a series of objections that he'd like to lodge about the Commonwealth's closing, which I'm going to give you an opportunity to do in open court with the Commonwealth in open court responding. And also I went over the schedule. So as I told council, my intention is to take as long of a period of time as I need to reach a verdict, provide the court staff and council with 30 minutes notice, and come out and announce my verdict, some of my reasoning here in public, and whatever time that works. In other words, if it's during our traditional lunch break, so be it. You folks will have a half-hour notice, which means that you'll be able to go and have coffee or lunch or whatever, as long as you can get back here. All right, so that's how we've worked that out. We also discussed at sidebar the fact that in a jury trial, we never provide the jurors with ammunition and a firearm, even with the trigger block at the same time. So my intention is that Mr. Ruane, our assistant clerk, will keep possession of the ammunition, and the firearm will come back in chambers with me along with the other exhibits. When and if I need the ammunition, will be switched out. All right. Okay. Globally, have I said in open court what we discussed?
Yes.
Okay. All
I
right.
love
So
this,
Mr.
Judge.
Bradel, I'll hear you on the objections.
Yeah, let's go, Bradel. Object.
So Judge, traditionally we do this at sidebar, but as you mentioned, we don't have a fact finder here that we need to talk off to the side too. So in open court, I'm happy to do this. Sure. Yep, I'll go back over everything I said at sidebar, Your Honor. Judge, the first objections I have to counsel's closing argument center on ballistics issues. The first part is that counsel picked up the gun and used it 3 times. Prior to that, counsel provided what I would consider to be expert testimony on the operation of the gun. I think it exceeded the scope of what Detective Bonasaro talked about. He said that it had to be a scientific certainty that this gun was racked by Kelsey Fitzsimmons. Mischaracterizes the defense position that we're not saying necessarily that it did or didn't happen. We said that Kelsey Fitzsimmons didn't rack the firearm. And we have a completely different version of events. So no one's saying that it didn't happen. We're saying that Kelsey didn't do it. And to characterize it like, you know, that it had to be racked by Kelsey Fitzsimmons is not fair argument, and it mischaracterizes the state of the evidence.
Good objection, good objection.
The second objection relative to ballistics, Your Honor, is that counsel was acting out. I believe it was the second time he picked up the firearm. Counsel was acting out on Noonan's story that Ms. Fitzsimmons had accessed the firearm from the chest and picked it up to point it at Noonan's face. And on Noonan's testimony, she just pulled the trigger and it clicked. Counsel's acting it out. Prior to pulling the trigger, counsel racked the firearm and then pulled the trigger. And that's not what happened on even Noonan's testimony.
I'm happy to allow you to make a record, but the fact that there's 2 different versions of what folks testified about is fair game. What the issue right now is whether the Commonwealth argued items that were not in evidence or attempted to draw inferences from items that were not in evidence. So the disagreement about the racking is just not before me.
Well, that's why I bring it up, though, Judge, because this racking issue has been brought up to the forefront, and he did something that is not part of the evidence. No one says that she racked the gun before the first shot, and that's what he did when he acted it out. So that's why it's a mischaracterization. I'll just rely on Your Honor's discretion.
That's not what Mr. Kubatosi did, though.
I did see him rack the firearm before he fired the second shot. He did it the second time, Your Honor.
Okay, I'm having trouble understanding. Again,
it's just that when you act out the testimony, you have to do it accurately, and he did it.
I'm going to say this in open court, and it won't be the last time I say it. Whether or not Officer Noonan exercised reasonable use of deadly force is not before me. That is not my decision.
I agree with you, and I say it on credibility.
And hold on, and whether the North Andover Police Department followed procedure in executing, serving this restraining order is not before me. Child custody is not before me. All right, visitation is not before me. What's before me is, has the Commonwealth proved beyond a reasonable doubt that the defendant pointed that firearm for any perceptible amount of time at Officer Noonan? Okay, so all of this is just not helpful.
And I offer it on credibility, though, Your Honor.
Okay.
Wow.
Also, the Commonwealth said that on the scene, Ms. Fitzsimmons didn't say part of her story there, so therefore she's making it up. And whenever the Commonwealth tries to argue that somebody, a defendant, didn't say something, that's very dangerous ground for the Commonwealth, Your Honor, that the defendant is under no burden whatsoever to say anything, Your Honor. And here to suggest that she's lying because she didn't say part of her story when she's shot in the chest at the scene is unfair argument, but it also violates her right to remain silent. And it's an intrusion on that, so I would object to that. I ask you not to consider that, Your Honor.
Except that, Mr. Bradle, she waived her right to remain silent,
right?
She testified. So
at the scene, though, Judge.
Isn't it fair game for the Commonwealth to discuss the testimony that your client offered?
The testimony, yes, but he's saying that at the scene, she didn't say XYZ when she didn't have to say XYZ at the scene. And that's, the Commonwealth can only argue that when a defendant makes a comprehensive statement and leaves something out.
Uh-oh. What did you do? Ugh.
To get her dog. So
Oh, man.
client that she wanted to kill someone else.
Let's see.
Client that she wanted to kill someone else, which didn't
Austin.
happen. That was not the statement. So that's a very important, very dangerous, very unfair, very prejudicial misrepresentation of what was attributed to Justin Elaine in the lobby. She never said anything about killing someone else. He didn't even he didn't say that she said that. So I ask you to strike that and not consider it.
What about the
And the
dog?
last thing, Judge, about lying about the dog on the restraining order, Your Honor, that trying to take her dog. And it is in the complaint to the restraining order by Justin Elaine.
I know you're trying to do a second closing, but the evidence is what the evidence is.
Yeah, but Judge, you can't say, when you have the discovery on the point, you can't say that something is a lie when you have the papers that show it's not a lie. And the box was checked in the complaint to get her dog. So that's a mischaracterization of the evidence that needs to be corrected, Your Honor. And that's my last point. Thank you.
So, Commonwealth, from my perspective, with all due respect to Mr. Brado, who's done a terrific job advocating for his client, I view that as nothing more than a rebuttal to the Commonwealth's closing. So I'll give you a few minutes to rebut these things. Let me say this, though. I don't believe that there was any evidence before me that Miss Fitzsimmons was sectioned previously. I think that the way I view the evidence is that this is what the police believed. It was part of their state of mind in serving it. But I'm at a loss, frankly, that, in other words, what I'm saying, Mr. Bradel, is out of all the items that you argued about the Commonwealth purportedly arguing something not in evidence.
Yes.
This sectioning, alleged sectioning that happened prior to this,
Yes.
there's no evidence of that before me. There's mention of it, and it goes to the officer's state of mind. So, and that's all that in fairness, that's all that you argued, Mr. Gubitosi. But I guess what I was getting at is if there was anything at all that came close, that would have been it. But Mr. Gubitosi, I'll give you a few minutes for your rebuttal to the rebuttal.
I don't think I trust you to have sifted through what's relevant, what's not relevant. The evidence is what the evidence is. Closings are not evidence. I would suggest to you that, yes, I do need to be heard, I guess. That I argue the evidence that came from the witness stand and from the exhibits to Ravanasaro absolutely describe the ways that firearm works and how a round gets into the chamber, and I limited my explanation of that to what he described and the like. I don't need to make a second closing. Thank you.
You just did that. I respect that on both sides. All right, so at this point, why don't we, I said that I was going to step off for the gathering of the evidence. Let me not do that. I'd like the council to just make sure that all the evidence, the exhibits are in order. You'll note your contentment on both sides. If you folks can take a look at the verdict form as well. I don't know if you already have. It's not complicated, but do you want, Mr. Brale, have you seen the verdict form?
No.
All right, so one of you, officer, do you mind? Officer?
What do you mean you haven't looked at the verdict form? You went over the elements yesterday. Surprised you didn't look at the verdict form.
Commonwealth is consented to that.
Same.
All right, content with the verdict form, but we're still working on the exhibits,
Yeah,
right?
we'll take it.
Yeah, that's fine.
Wow. Oh, so tough. I hate to be in the judge's shoes. I'm sure he's like, I don't want to do this. All right. So while they're going over that, we'll just talk a little bit more. Okay. So the elements of the crime. We talked about this yesterday. So she is facing two different, the case hinges on two conflicting versions of the same event. Assault with a dangerous weapons. The intent was that Fitzsimmons intended to commit a physical battery shooting on Noonan. Did she do that? Oh.
Availability of this courtroom this afternoon, so we'll check them on that.
Did Kelsey Fitzsimmons intend to commit physical battery by pointing a weapon at Officer Noonan? Did she take a step toward the battery by drawing her service weapon and pulling the trigger? Did she come reasonably close to succeeding? And the assault was committed with a firearm. Did she intend?
On behalf of the Commonwealth, does the Commonwealth contend with the exhibits?
Yes.
Attorney Bradel, on behalf of the defendant, is the defendant content with the exhibits?
Yes.
And that would be for both of you, exhibits number 1 through 98.
Right.
Correct?
Plus the chalk, Mr. Clerk.
Yes, and the jury instruction. Yes.
Okay, 98, I thought we had, weren't there 100 exhibits?
No, 90.
Okay, all right. I'm sorry, okay. All right, so, and Mr. Wayne, I think it makes sense, as in a jury trial, for you to swear our court officers in.
Could you all raise your right hands? Do you solemnly swear that you will keep the court in some convenient place until he has agreed that you will not suffer any person to speak to him, nor speak to him yourselves, unless by order of the court, or to ask him if he has agreed? And when he has agreed, you will return him into court unless the court shall otherwise order, so help you God.
I do.
All right, we will stand a recess for my deliberation.
All rise, please.
All right. So there you have it. Ooh, all the evidence is in. The closing arguments have taken place. All right, so we were back on, did she intend? Did she intend to put Noonan in fear of immediate battery? Did she engage in conduct that Noonan reasonably perceived as an immediate threat? And was the conduct involved a dangerous weapon? So, Patrick Noonan testified that Fitzsimmons pointed her gun at him and pulled the trigger. He stated it made a click because there was no round in the chamber, and he fired his own weapon twice, hitting her in the chest, the tap rack, whatever. He believed that she was attempting to chamber the round. Is he just covering himself, or is that exactly what happened? A ballistics detectives confirmed that Fitzsimmons' gun had a round in the chamber when recovered, but testing showed it did not fire during the incident. I'm not sure about that. I guess we could go back and see that. The defense says that she was experiencing a mental health crisis involving postpartum depression. Not really. She was experiencing a mental crisis because everything, she believed was going to be gone. And that she only ever pointed the gun at herself. So we are on verdict watch. But what I really would like to do is I really would like to go back to the ballistic expert and see what he had to say. So let's see if we can go back. Let's go to Court TV. No, that's day 4. I don't want to go to day 4. I want to go to let's go to Court TV. Kelsey Fitzsimmons. Where's your list? Let's see. Oh, there's lots going on in Court TV. I want to hear the ballistics guy one more time. Let me see if I can find it really quickly here. Well, it's not day 3. It was day 2. That says day 1. Death by antifreeze. Let's see if we can why don't we just go day 3? Let's see what it does. Day 4, day 4, day 3. Day 3, day 2. Actually, I think I need day 2. Because today's 4, that was 3. Let's go day 2. Okay, here we go. Day 2. Let's see if we can zoom to the ballistics expert.
Are these? Yeah, I'm not on.
Stryker
Okay, here he is.
and Officer Houston of us assigned. We were on the same scene
Okay.
Did you speak with him in the days following?
in front of the. It should land in the general vicinity of the shooter, but we also have variables if that casing was kicked or manipulated in some way, or if it deflected off another object.
And I think we just talked about this, but what does caliber refer to?
Caliber is the diameter or length of that casing.
I'd like to talk about a semi-automatic firearm. Are you familiar with those?
Yes.
And how does a semi-automatic fire?
Okay.
Load that live cartridge and put some external force on that slide to cock it.
And is cartridge synonymous with magazine?
Cartridge versus magazine. So a cartridge would seat in a magazine.
So the cartridge holds the projectiles or casings in the magazine.
Yes.
And what part of the gun is the magazine?
So it's an external piece that's inserted into a magazine well.
So a user would take the magazine, enter a cartridge which contains the bullets, and then seat it in the handle of a semi-automatic weapon. So
the person would load the ammunition inside of the magazine. The magazine will have a spring tension as well as a follower on top. That spring tension pushes that live cartridge to the top of that magazine at all times. That live cartridge is stripped by the slide or manipulated by putting that live cartridge in the chamber manually, but ultimately you do have to cock that weapon to fire it.
I'd like to direct your attention to June 30th of last year. On that date in the evening hours, did you get called to go somewhere?
I did.
Where did you get called to go?
To a residence in North Andover.
What information did you have when you arrived?
Information I had was there was a police-involved shooting, which required a supervisor to attend the scene.
And that's why you went?
Yes.
Okay. What time did you arrive?
I don't recall exactly what time. It was in the evening hours.
Did anyone else from your unit respond?
Yes, I had a trooper, Chris Pierce, as well as trooper Andrew Valeri.
And the three of you responded from firearms identification unit?
Yes.
And what was your purpose on scene?
We wanted to document the scene. We wanted to inventory all personnel that were involved in the shooting, whether they fired or not, to inventory their weapons, to account for all live cartridges.
And again, is that standard procedure for an officer involved shooting?
Yes.
When you responded, who was on scene?
There was several detectives from the Essex County Detective Unit, as well as Andover police personnel.
North Andover police personnel?
North Andover, yes, Mike, sorry.
Were you directed to a particular part of the house?
I was. There was a particular part in the top of the stairs where there was a firearm located in a safe, as well as a bedroom where we recovered a 2 discharge casing as well as a projectile.
And did you or someone from your unit or someone from the state police take photographs that evening?
Yes, we had crimes and services photograph the scene.
And what is
We are going back over the
That's fair.
testimony of the expert for the firearms, because that was a mention that the it was mentioned in the closing arguments of the prosecution.
Massachusetts State Police, they document, they photograph the scene, they videotape the scene to preserve the scene, as well as do prints on firearms casings and so on, as well as footwear impression markings.
May I approach?
Yes.
Sir, I'm showing you 9 photographs. I just asked that you take a look at those and let me know when you're done.
While you're doing that, counsel, Mr. Brady, will the defense be objecting to any of these?
I don't know what council has up there.
Okay, thanks.
I understand.
I want to get to the part where he says about the gun.
Sir, what number was that again?
81.
81, thank you.
Is Exhibit 82 a different angle of that same, you were trying to photograph that same discharge cartridge casing?
It is.
Showing you Exhibit 83. What is the picture?
We're close.
So-
From
Show.
with from the
Vision conditioner, the-
it appears to be another discharge cartridge casing by placard number 1.
And
Where that's or a bunch of marks.
summary, fair to say that you recovered 2 discharge cartridge casing and 1 spent projectile.
Correct.
Sorry, I was distracted. Can you ask that question again?
Sure. In summary, is it fair to say that you recovered 2 discharged cartridge casings and 1 spent projectile that night?
That's correct.
Thank you.
Your search of that bedroom,
I did.
and what else?
The 2 discharge casing and the projectile.
May I approach, Your Honor?
Yes.
We're back on record on the Kelsey Fitzsimmons matter. All counsel and the defendant are present.
Okay, you may continue, counsel.
Thank you. Detective Lieutenant, is it true that you took possession of a number of firearms the night of June 30th, 2025?
I did.
And whose firearms did you collect?
There's 2 North Andover police officers' firearms and another firearm that was recovered at the top of the stairs at the residence.
And the 2 North Andover police officers, was that Tim Houston and Patrick Noonan?
Yes,
And did you also inspect Lieutenant Daly's firearm on scene?
I did.
And what did you determine with respect to Lieutenant Daly's firearm?
He had,
Well, I'm sorry. This almost only happens in Lawrence. But the window's open over here, which is what we need for, because of our HVAC, but I'm having trouble hearing. Do you mind closing that?
loaded. There wasn't any unaccounted for rounds of ammunition.
Okay.
Wait, I'm confused because I thought you took Officer Houston and Officer Noonan is what I wrote down, but is that?
Fair to say you took Officer Houston's firearm and Officer Noonan's firearm.
Correct.
And did you take Lieutenant Daly's firearm?
I did not.
Did you just examine the number of bullets in his magazine?
Yes,
Well, she's leading because the judge was distracted by the outside noise. So, and I'll allow you to do so as well, Mr. Brady. So overruled. All right. So now I understand. Thank you.
And sir, I'm next going to ask you if you recognize what's shown in Exhibit 10.
Yes, that is the firearm at the top of the stairs, as well as a magazine with numerous.
Okay, so it is open. It is open. Okay.
Live cartridges in it, as well as one loose live cartridge.
Is this the loose live cartridge here?
It is.
I'd like to ask you about your major findings in this case. Based on your training and experience, did you conduct microscopic analysis with respect to the projectile and cartridge casings that were recovered from the bedroom of Phillipsbrook Road?
I did. So I test fired all 3 weapons and conducted a microscopic examination of the class characters as well as the individual markings that were left behind from the firing process. I was able to conclude that the weapon that was fired by Officer Noonan created the discharge casings that were recovered in the bedroom, as well as the spent projectile that was recovered above the air conditioner.
And were you able to exclude any weapons?
I was able to exclude the other firearms.
I'd like to change gears a little and talk about the weapon that was recovered from the black safe at the top of the stairs. Did you do anything with respect to that gun?
I test fired that weapon with 2 live cartridges from submitted ammunition.
And what was your conclusion?
That weapon did not fire the discharge casings as well as the projectile that was recovered.
So the gun from the black safe was also excluded from the discharge casings and the projectile that were recovered from the bedroom?
Correct.
But did the gun operate?
It did operate, yes.
Was there any problems with its operation?
There was no malfunctions.
Did you bring with you today a box?
I did.
And what is contained within that box?
I believe it was the that Glock firearm that was in question that was recovered at the top of the stairs.
Is that box packaged in the standard way that the ballistic unit packages firearms?
It is.
If you could open the box and explain what is in the content, what's contained within.
Weapon safe is original as well.
Okay, thank you.
But in the meantime, may the box and the contents be marked for as
Individually, firearm trigger lock on there.
Magazine that you recovered from the gun in the black safe, what was the total capacity of that magazine?
17 live cartridges.
And is that how many live cartridges that weapon can hold?
That's how many cartridges the magazine can hold. So what's called a top-off method. So you load the magazine with the 7 live cartridges. You would chamber around. You take the magazine out of the magazine well, and then insert another live cartridge. So essentially, the magazine will be fully loaded with 7, and then there will be 1 live cartridge in the chamber.
So you said 7, not 17.
My apologies.
No, I'm asking, that's a question. You mean 7, right? Not 17?
7. The magazine is 17 live cartridges capacity.
17
17.
is the capacity. Okay.
17 is the capacity for the magazine that was recovered from the black box.
Correct.
And so when you add an extra round, what's the capacity for the weapon itself?
So we'd call it 17 plus 1. So essentially 18 live cartridges.
So this one only had 17?
So getting back to that, in that black box, in this, I'm showing you Exhibit 80. Exhibit 80 is the gun, the magazine, and the single live projectile that is contained within the box in front of you. Is that correct?
Yes.
And when you examined this firearm, how many bullets were in the magazine?
There were 16 live cartridges in the magazine.
And how many live projectiles were in the safe?
There was 1 loose round live cartridge in the safe.
And that is reflected in the 1 loose round cartridge. That's in Exhibit 94, is that correct?
Correct.
Are you familiar with the term dry fire?
I am.
What's that mean?
So you are cycling the weapon without a live cartridge in the chamber. So all the same steps are going to happen. You're going to cock that weapon. It's going to have that trigger bar or that striker be sent to the rear. It's going to be held in tension by that trigger bar. When you depress the trigger, it's going to create that trigger bar to drop. The firing pin is going to move forward through the aperture and potentially strike any live cartridge that's in the chamber.
And what happens if there's not a live cartridge in the chamber?
So you'll hear an audible click.
With the court's permission, may Detective Lieutenant demonstrate?
Any objection? No. Demonstrate with.
A dry fire with no projectile in the weapon at all, no projectile, particularly in the chamber.
Yes.
So if you could stand up and demonstrate.
All right. Again, there's nothing in the magazine well, nothing in the chamber currently. So the weapon currently is cocked. You've moved the slide forward, still in the cocked position. You still have that trigger bar, it's moved backwards. And then when you pull the trigger, you'll hear an audible click because it's releasing that striker. That striker is going to move forward and hit where the aperture where the firing pin would protrude. So you'll hear the click. And then in order to reset it, so right now you have a dead trigger, it's not going to do anything. Again, pull the trigger, audible click. And that's what you'll hear. If you have nothing, if it's halfway, you'll have a click as well. So if it's not all the way chambered, it'll click as well. So what we call it is out of battery. So the weapon is locked to the rear. You'll have the slide forward. Now the weapon is battery. So you have an enclosed live cartridge. There's nowhere for that live cartridge to go when it's fired, but out the barrel.
And then, so the term that you used, battery,
It's out of, so once the live cartridge is loaded, that weapon is now in battery. So you have the breech that is right behind that live cartridge. So when you fire that weapon, an explosion is going to happen. So you're going to have the firing pin is going to hit that primer. Primer is going to ignite the powder. Powder is going to build up gases. Projectiles are going to go down simultaneously. You're going to have an explosion, which is going to cause that slide to go backwards. The extractor is in contact with that live cartridge. It's going to rip that discharge casing out. It's going to hit the ejector, which is pretty much a metal rod, and it's going to eject out this ejection port, which is right here. There's an ejector right in there. An extractor is like a little claw that's attached to that rim of that live cartridge or that discharge cartridge after firing and pulling it right out. All in one function, and then that slide is going to go forward and load the next live cartridge.
thank you.
So based on your training and experience, would you hear that click if there was a loaded magazine in the weapon, but no bullet in the chamber?
Yes.
And based on your training and experience, what would happen if the gun was cocked and there was bullets in the magazine and you pulled the trigger?
If there wasn't any live cartridges in the chamber, nothing would go off. You'd hear a click, but nothing would go off.
And then how would you get a bullet to go into the chamber?
You'd have to physically, manually load that bullet or push that slide forward to load that live cartridge from the magazine.
May I have a moment, Your Honor?
Yes, take your time.
Okay. I don't remember him saying anything whether or not that round cycled through the gun and he could conclusively say one way or the other. And I just watched it. Anyways, that's what we're doing, folks. This is where we're at this current moment. We are on verdict watch. So like and subscribe if you want to see more, but we're on verdict watch, so we'll let you know if there's a verdict in the case. Thanks for watching. Thanks for watching Legalese 1, 2, 3. If you like what you saw, please like and subscribe for more content.